Officer, in the past, you've been the subject matter of disciplinary proceedings within the your town police service, correct?
Correct.
On one occasion, you were formally reprimanded by a superior officer for having buy money gone missing, right?
That is correct.
You were working as an undercover officer. You were given buy money, right?
Yes.
Money which your police service and the taxpayers of your town provided to you to do your job, right?
Right.
And it's gone missing.
Correct.
Right. You misappropriated it.
Correct.
And in the course of that, obviously, you were formally reprimanded by your police service, correct?
Correct.
You've also been charged with a criminal offense, isn't that right?
That's correct.
Well, again, sorry, just hold on, witness. Again, the Crown will make a similar objection to what it has already made as it relates to the reprimand. Again, this would be an issue that the witness would not be present for submission.
Yeah, the witness isn't here.
As I understand the situation with regard to the criminal charge, that in fact this officer was charged, but ultimately the charges were withdrawn by the Crown. And in my respectful submission, any reference to that or any cross-examination to that is not relevant to a charge that has since been withdrawn. It is highly prejudicial, and there's no probative value to it.
Mr. Marley hadn't said that. Are you telling me that he was charged, but the charge was withdrawn?
That's correct, sir.
Mr. Marley, on that basis, what relevance does it have if the charge is withdrawn? Either if he's found not guilty or the charge is withdrawn, it's as if it never happened. He should have the same benefit of our presumption of innocence that any accused person has.
As Your Honor's already observed, this man is not an accused person. This is, in my respectful submission, another incident of prior disreputable conduct upon which Your Honor can perhaps rely on for the purposes of assessing overall his credibility.
Well, the problem I have with this, and I'm reading from Martin's, and it says, this is the summary at Canada Evidence Act, Section 12. This section does not limit the otherwise permissible defense cross-examination of a prosecution witness on the particulars of discreditable conduct that resulted in conviction. In fact, it does not limit otherwise permissible cross-examination of any witness other than the accused, which I think both you and Mr. Houle agree. A witness may be cross-examined about any discreditable conduct, including the circumstances of a charge for which the witness received a discharge or an outstanding charge. Where I part company with you and go towards what Mr. Houle says, the charge was withdrawn. If you wish to get into why it was withdrawn, maybe a witness didn't show up, maybe something happened, we end up with a second trial within this trial, which detracts from the focus of this trial. I'm not prepared to allow that question. If he had been convicted, or if he had been convicted and a discharge was registered, I think you're on solid ground. But once the charge is withdrawn, that means that a quasi-judicial officer like the Crown has made a decision. I'm not here to go behind that decision, and I think it would detract from the focus of this trial to allow you to enter into that inquiry.